Hello and welcome to the Jestrad Lecture on Water. I am Professor Michelle Bryan Mudd, an environmental faculty member at the law school, and I have the pleasure of telling you a little bit about this lecture series and introducing our distinguished speaker today. So this lecture series was created by Frank Jestrad together with his wife Elvira. They generously created this series, which stands apart nationally for its focus on water. Mr. Jestrad was an alum and friend of this law school, and although he did not specialize in the area of water law during his time as a lawyer, he worked in oil and gas. He was an infantry platoon leader and a captain who, through his practice and world travels, recognized that water is a fundamental part of our human conversation. Through the creation of this lecture series, he ensured that we can gather together to engage in important conversations about one of our planet's most precious resources. By housing the lecture at our law school, Mr. Jestrad also recognized that we are a place to have such conversations. We are located in a geographic space deeply connected with water, and our school's mission is to train new lawyers and serve the greater community in the areas of natural resources, environmental, and Indian law. With the Jestrad lecture, we have the privilege of spending time with speakers who have deeply thought and innovatively thought about the water questions of our day. It thus gives me great pleasure to introduce this year's speaker, Professor Robin Kundis-Craig, who has traveled here from Utah, where she serves as Associate Dean for Environmental Programs and the William H. Leary Professor of Law, the University of Utah S.J. Quinney College of Law, and where she is also affiliated with the Wallace Stegner Center for Land, Resources, and the Environment. Robin has a very special talent for writing about the law and the environment in a particularly accessible way. I commend to you her articles, which you can access online from her faculty page. She's an excellent writer. This makes sense when one considers her educational background. She's received a bachelor's degree from Pomona College in English and writing, and then went on to get her master's in writing about science from the Johns Hopkins University program, PhD from UC Santa Barbara in science and literature, and her law degree from Lewis and Clark School of Law, specializing in the environment. I first met Robin when I was a new faculty member attending a national conference on environmental law, and she immediately revealed herself as someone who loves to mentor others and bring them into the water conversation, both students and colleagues, which is something wonderful about her. True to form, when Robin presented this last spring at our public land law conference, she immediately befriended several of our environmental law students. They were so excited that she was coming back to talk again today. And tomorrow the students in water law will benefit from her teaching when she comes to visit with our class. So we're grateful she's staying on an extra day. So Robin is a nationally recognized scholar in all things water, which is not the case for every water law scholar. She brings a really holistic and science-informed approach to her writing. She's written about climate and water, energy and water, the Clean Water Act, how water issues and land issues intersect. She's spent a lot of time writing about oceans and rivers, marine biodiversity, traditional water law, and the tensions between state and federal governance over water. In addition to having great breadth, one cannot help but note that her work is written for the real world. She brought that up again this morning when we were visiting. Her hope that the things she actually writes will make a difference for real world. And she asks us all to look forward in time and be prepared for what will come next. So it's great scholarship, and her ability to straddle the worlds then of theory and practice is also reflected in her leadership roles that she's been appointed to in government and in the American Bar Association. In her work, she's also taken a particular interest in Montana and its public trust over waters. And it is that work with the public trust, along with climate, that she shares with us today. So please join me in welcoming Robin Kundis-Craig for her talk on public trust in a time of climate change and post-PPL Montana implications. Robin.
Well, thank you, Michelle. This is on, right? Yep. Okay, good. All right. Good afternoon to all of you. Thank you for spending your lunchtime with me, and I hope it will be a somewhat provocative and interesting survey of what states are doing with their public trust doctrines before we come back to Montana. I'd like to thank Michelle for concocting this way back last April to have me out here, and to Dean Irma Russell, a longtime friend who helped make this all happen. I'm delighted to be here. And my main goal this afternoon is to convince you all that the public trust doctrine is a valuable common law doctrine worthy of state experimentation as a tool for dealing with water resources shortages and other changes to water resources that climate change is precipitating. So, with that, there we go. What the argument is basically going to be is that state public trust doctrines, and I use that plural very deliberately. One of the arguments I've made repeatedly is that there is no longer a public trust doctrine in the United States, that every state has basically gone its own way with a few common starting points, but that they can help facilitate climate change adaptation. And to quote Oliver Wendell Holmes, the strength and the genius of the common law lies in its ability to adapt to the changing needs of the society it governs. This is a long tradition out of England as well as in the United States, that as society changes, our common law changes as well. And climate change adaptation, I would argue, is likely to rely heavily on the common law to the extent that law and policy need to change, in part because climate change causes intensely local effects, and as a result, different parts of the country are going to need different legal and policy innovations. It is a self-evolving stressor to legal rights and institutions, meaning there's probably not going to be one set solution we can land on and be good for decades. We're going to have to be continually changing. Common law is a lot better at that than, say, Congress or state legislatures. The end goal of climate change adaptation still hasn't been defined and probably won't be able to be defined for quite a while, if there is in fact such a thing as an end goal. And again, you're going to need that flexibility and ability to adapt that the common law is much better at than other forms of law. Now, state public trust doctrines are, for the most part, common law doctrines. There are a lot of states that have put in some statutory provisions or constitutional provisions, but a lot of the specifics of what the public trust doctrine can and cannot do in a given state is still a matter of common law. And that common law already has a history of adapting and evolving. Our public trust doctrine, even generalizing to the United States, is not what England had. It's not what Rome had. It has already adapted itself to the realities of the United States and is continuing to do so as we speak. And I'll give you some examples of that. And many states have already explicitly, and I do emphasize the explicitly because I think some of them are going to find it implicitly in the future, but have explicitly described their public trust doctrines as evolutionary. They are doctrines that are meant to change and that will change over time, allowing for the future adjustments that need to be made. So that is an overview. All right, backing up historically, when you read the history of the public trust doctrine in the United States, you usually land on the Institutes of Justinian as a starting point from Rome, which said that the rivers and ports are public, and hence the right of fishing in port or in the rivers are in common. And the basic idea was that some amenities are too important to society as a whole to put them into private ownership. So some things need to stay public, or at least partially public. Now in England, that same concept evolved into a different version of a public trust doctrine. And in particular, the public part of the public trust doctrine in Old England was the right of the crown to control navigation and fishing for the big fish. Okay, not the little things, but the big fish, the sturgeon, the big ones, all right? And that was actually incorporated into the Magna Carta. We normally think of the Magna Carta as a first statement of individual rights, but that right was explicitly preserved to the crown in the sense that the crown could remove any interference with fishing in the Thames, the Medway, and all the major rivers in England. And that led to a potential weirdness in the United States because we had a moment in time, and this is one of the few areas of law where this really still matters, we had a moment in time where we had 13 independent states who inherited all the rights of the crown before we had a federal government. So one of the questions in the formation of the United States was who was going to end up with that authority and what was it going to look like in the United States. All right, the answer was a lot of it is going to lodge in the states. Not all of it, but a lot of it. So the classic place for starting with the public trust doctrine in the United States is with state ownership of the beds and banks of navigable waters. If you own the submerged lands, you control the waterway above it, is the basic idea. And that is quite clearly, hasn't changed, a question of federal law. Supreme Court, U.S. Supreme Court has been very clear about this repeatedly, including in PPL Montana, that who owns the beds and banks, as between the states and the federal government, is a question of federal law. And over time, this doctrine has evolved. The states own the beds and banks of all tidally influenced waters. So anything influenced by the ebb and flow of the tide should belong to the states. Some places that matters a lot, some places that doesn't matter at all. But the Columbia River, for example, between Washington and Oregon, is tidally influenced all the way back to Portland, Oregon. So that's a lot of river that you get by tidal influence. More commonly, more importantly in the United States, and this was an evolution that I'll get to in a second, states own beds and banks of all waters that are navigable, in fact, at the time of statehood. And that was the critical issue in PPL Montana's, how do you prove navigability at the time of statehood? But that definition of navigability for state title is very much a commerce-based definition. Waters that are used or susceptible of being used in their ordinary condition as highways of commerce. Okay? So keep that in mind, because that's one of the things that states have changed. All right, now, as far as the law was concerned, the evolution of the public trust doctrine itself, the U.S. Supreme Court mentioned it in several cases, kind of in passing, but the big U.S. Supreme Court statement that the public trust doctrine exists in the United States and can influence what happens with navigable waters came in Illinois Central Railroad versus Illinois in 1892. This involved Illinois' first conveyance of the lands beneath Chicago Harbor and then attempt to undo that conveyance to railroads to get Chicago Harbor developed. And the Supreme Court said essentially, no, the state of Illinois cannot completely convey control over these navigable harbor waters to private interests. They can't undo that grant. It was never legal to begin with, more accurately. And they can't completely convey it away. But states own these lands in trust for the people of the state. And therefore, they cannot completely abdicate control over them. So, after Illinois Central, the apparent public trust doctrine in the United States said that lands under navigable waters, again using that federal test, are held by the state in trust for the public to protect three basic uses: navigation, commerce, fishing. Okay, it's very much tied to commerce. fishing thrown in there as well. And because of this public trust, states are limited in their ability to completely alienate title. They can't give up what's known as the jus publicum, or the governance public aspect of their ownership. All right, so far so good, except Supreme Court not entirely clear on where this law was coming from in Illinois Central. Doesn't cite much of anything, really, for the source of the law. It's a long case. You can read the whole case. Trust me, not much in there. And so the source of where this came from is debatable and has been actively debated ever since. What exactly was it relying on? First logical conclusion is it's got some federal law basis. It came from somewhere. Federal constitutional law, one of those penumbral things we've got in our Constitution. It's in there somewhere, you know, trust us. Possibility, was it federal common law? Another possibility, navigable waters are inherently federal in the United States. That's still true. So maybe this was just an aspect of federal common law. And there are suggestions of that in Illinois Central, that this is in fact a federal doctrine. More importantly, I think today, most states took it as having a federal law, and in particular, federal constitutional basis. So if you look at the laws that developed in a lot of state Supreme Courts, they assume it's in the federal Constitution somewhere. Okay? However, the U.S. Supreme Court has backed away from that since 1892 and said, no, this was all a matter, or at least part of it was a matter, of state law. So Appleby versus City of New York, 1926, New York had been authorizing all sorts of people to fill in the Hudson River to create Manhattan, basically. And the legality of that was debated in the case. And the U.S. Supreme Court said, hey, the legality of it is a matter of New York state law, not a matter of federal law. Don't come complaining to us. Go to New York. And by the way, our decision in Illinois Central was necessarily based on Illinois state law. I challenge you to read Illinois Central and find that in there anywhere, but that's what they said in Appleby versus City of New York. More interesting case, 1997, I didn't put the date up there, Idaho versus Coeur d'Alene Tribe of Idaho. Again, the Supreme Court said, yeah, the public trust doctrine is a matter of state law. What it means is up to Idaho. But it also has this long poetic speech about how important the public trust doctrine was nationally. So again, suggesting that it was not just state law, there was something else going on with it. And then, of course, we got PPL Montana versus Montana, 2012. The bulk of the case, if you're not familiar with it, is mostly about whether Montana owns the beds and banks of three rivers, whether they were navigable at the time of statehood, how exactly you prove that, what kind of historic record there was about all that. But at the very end of the case, the public trust doctrine came up, and the Supreme Court said clearly, for the third time, I tend to take them seriously when they say something for the third time. So, for the third time, that no, the contours of the public trust doctrine are a matter of state law. Okay? This is a matter of state law. So, questions left after PPL Montana about the public trust doctrine. Michelle's written on this, I've written on this, this is still being actively debated. But, okay, the Supreme Court again made it clear in PPL Montana that title to the beds and banks of navigable waters is still a federal question. Federal constitutional question. It comes out of the equal footing doctrine, which is another one of those doctrines that is declared to be constitutional and is nowhere mentioned in the Constitution. But nevertheless, Supreme Court clear about that one. That's federal, that's constitutional. But it left open the issue of whether the bare existence of a public trust doctrine also has a federal law basis. The contours clearly up to the states. Can they get rid of it entirely? All right, can they get rid of it entirely? Another question that's left open is there a lot of other laws that went into the formation of states, such as the Northwest Ordinance of 1787, most applicable to the Great Lakes states, which says that the waterways shall remain forever free. Various state enabling acts, every state's got one, also talk about the waters of the state and how they can be used. So maybe those will be federal law bases for state public trust doctrines, and the bare existence has to be maintained. And then finally, last question, which is likely to become more and more interesting. Are there any limits on how far states who want to expand their public trust doctrines can go, either under state law or under federal law? And some of them get pretty expansive with it. So questions on both ends. Can a state get rid of it entirely? I thought at first Arizona was going to be the test case of this one because the Arizona legislature's tried to get rid of their public trust doctrine quite a few times. And the Arizona Supreme Court keeps saying, no, it's a federal constitutional doctrine, you can't get rid of it. It may be Utah. Our legislature is working hard to severely limit or get rid of ours, so stay tuned. That question may have an answer one of these years. But on the other end, states are getting very creative in response to climate change and other pressures on water about what their public trust doctrine will protect and what it will protect it against. So, like I said, why I think these will be increasingly important is because of what climate change and other climate issues are doing to water resources. So, no surprise, even before prolonged droughts, population growth, population shifts meant that droughts were predicted and water shortages predicted in many parts of the United States. This was one map of the situation by this year, done a few years back. Again, non-climate change predictions of severe shortages for 2025. As with most maps, anything in red is in particular peril. So the Southwest and parts of California in very grave danger of water resource or water shortages for a variety of reasons. Like I said, a lot of it is population growth. Groundwater, not a real solution in most parts of the country. A lot of aquifers already being overdrafted, mined, depleted, coming up on unusable. And the poster child for that is the Great Plains Aquifer, underlying most of the middle of the country, being mined at a phenomenal rate, and projections are anywhere 5 to 10 years from now at current rates of pumping, not going to be commercially usable anymore. So, not a solution. But we got a lot of different impacts on water resources being added by climate change on top of those basic problems. You've got decreased flows in some parts of the country. You have rapidly varying amounts of water in other parts of the country, periods of drought followed by periods of flood, followed by drought. You look at what's been going on with the Missouri River in the last years and its effects on the Mississippi. That's been the pattern. Different timing of flows. Spring snowmelt coming earlier in the year, less water later in the summer. How hot the water gets, various parts of the year. Ground or saltwater intrusion in many coastal states is becoming an issue. If you've got less pressure from the fresh water flowing out to the ocean, you get more salt water coming in, especially into the aquifers. It's a huge problem in Florida and becoming a problem in parts of California. And you don't get groundwater recharge at the same rates or to the same degree as you get, as historically has been expected. So a lot of impacts on water resources. And that's all that together, not just climate change, but all that together has been causing some public and private stresses about water resources in various parts of the country. And this isn't just a Western problem. I'm going to start with the West, but it isn't just a Western problem. If you've paid attention at all to what's going on in the Sacramento, San Joaquin Bay Delta near San Francisco, the fresh water coming in is piped through this huge pumping system, Central Valley Project to Southern California, that's causing a variety of issues, endangered species issues, water shortage issues in terms of drought, various governmental entities not being able to deliver their contractually promised to deliver. And at one point, Judge Wenger shut down the entire system and said no water to anybody until we figure this out. He backed off of that. But, you know, huge issue, still ongoing, a big mess, and drought is exacerbating it as it does many places. Klamath River Basin straddles Oregon and California, Northern California. Again, several years of drought where farmers were not getting the water they assumed they were entitled to. Caused a series of lawsuits, some of which are still being fought out. We've got salmon fishers, we've got tribes, we've got people fishing the ocean who need the fish that aren't coming down. And hopefully there's a deal to negotiate, or a deal has been negotiated, hopefully be funded, to remove 4 of the dams in the system, which is supposed to help everybody out. No longer economically viable for hydropower and may help the whole system out. Nevertheless, the litigation is still ongoing over various aspects of that system and whether the ecosystem needs are important enough to justify cutting off several of the private amenities, keeping in mind that cutting off one set of private amenities also supports the fishing interest. So it's not just environment versus private. Catawba River system, this is South Carolina and North Carolina. South Carolina ended up suing North Carolina in the U.S. Supreme Court, claiming that North Carolina was taking more than its fair share. North Carolina claimed that it needed a lot of this water as cooling water for electric power, and Duke Energy, for the first time ever in one of these cases, was allowed to intervene because it controlled so much of the Catawba River for energy production. North Carolina and South Carolina ended up settling their differences and took the case back out of the Supreme Court, but it was the first time since the early 20th century where 2 eastern states had sued each other to divide a river, so some sign that this is becoming a national problem. And then finally, as you may have heard, Florida just said it, or announced it's going to sue Georgia finally to divide up the Chattahoochee, Flint River, Apalachicola River system. Basic claim there is Atlanta's taking more than Georgia's fair share of the Flint River, which is causing water shortages in Florida, which are destroying the oyster industry at the end of that whole system in Apalachicola Bay. So again, another eastern system. We'll see if Florida actually files suit. They've threatened this before, but they have recently threatened to do it. All right, example number 1 I'd give of some of these stresses really coming to a head. A very recent example, Colorado and Lake Mead. As I hope most of you know, Colorado River is in its 20-something year of a drought, which may be the new normal. That's being debated. But anyway, a lot less water going into the Colorado River, which was already way over appropriated to begin with, than is historically normal. And so you get pictures of Lake Mead with that bathtub ring around it showing how far down the water is. Last month, the U.S. Bureau of Reclamation announced that the end of the summer transfer of water from Lake Powell to Lake Mead, which evens out the 2 reservoirs, was going to be 750,000 acre-feet less than everybody on the downstream end of the Colorado River was expecting. Immediately a problem for Las Vegas, Nevada, which you may or may not be worried about. But they are having to build a 3rd new intake structure into Lake Mead because the lake levels are falling below their water intake structures that are already there, so they're having to go low. Question for them is going to be, if these kinds of reductions occur for the next couple of years, are they going to be able to build it fast enough to be able to keep taking water? That's a real question for Las Vegas. It also has implications for Arizona and California. So, real life example. A little closer to home, and one of my favorite issues to hone in on every once in a while is the stress on cold water native fish. As waters warm up, as flows are decreased at the end of the summer, you have a real problem with cold water fish who are intolerant of much change in temperature. This was a report that came out of Montana a few years back, low flows, hot trout. Other parts of the Pacific Northwest facing the same issue with salmon, other fish that are intolerant of hot water. What do you do when your native fish populations are being subjected to water temperatures they can't tolerate, and there's no easy solution to getting them more water or colder water? All right, so that's background. What has the public trust doctrine already done to adapt to the realities of the United States? Well, first of all, I mentioned that navigability in fact test that the U.S. Supreme Court adopted. That is itself an adaptation to the realities of the United States. In England, the common law public trust doctrine said that the sovereign owns the tidally influenced waters. So anything influenced by the ebb and flow of the tide. And in reality, in England, that's all you need, okay? Any river of any importance in England is influenced by the tide. It's not that big a country. It's surrounded by the ocean. That gets you pretty much everything you want. Doesn't work so well for the United States. When you've got huge rivers like the Missouri, large stretches of the Ohio, the Mississippi, the Columbia, that are not influenced by the ebb and flow of the tide. And so the United States Supreme Court fairly quickly came up with the navigability in fact test. Don't care if it's tidally influenced. If you can, in fact, navigate it for commerce, it's covered by public trust doctrine and subject to state ownership. So one of my favorite quotes, one of the things I love about this work is I get to go read old, very old state Supreme Court cases. So the Ohio Supreme Court in 1856 was confronted with the issue of private landowners along the Mississippi River, very navigable, were setting up essentially river blocks and trying to collect tolls for anyone who wanted to navigate up and down the Mississippi River, claiming it's not influenced by the tide, therefore it's privately owned, therefore we can charge for people to cross our property. And if you've never read this Ohio Supreme Court decision, McManus versus Carmichael, the judge is just dripping with sarcasm. It's one of those, I can't believe this got all the way here kind of cases. But to quote the judge, are we to be told that the Mississippi River is not a navigable stream and its bed private property? The father of floods, private property. The great river, to see which the conqueror of Florida periled the lives of his followers, to find for himself a grave in its waters instead of gold in its sands, belongs to every petty owner who pays a dime for the land on its banks? The river, which carries to sea the products of millions of people, the boundary of states without number, which carries to a single port commerce numbered in the hundreds of millions of dollars, and numbers the ships which float on its waters by thousands, cannot be private property. Okay? So, very early declaration that there's no way the Mississippi River is going to be subject to every landowner along its banks who wants to charge a fee. No, this is public. We're going with public. All right. Does that distinction still matter? Yeah, go to Kentucky. For whatever reason, Kentucky, a landlocked state far from the ocean, decided that for purposes of its public trust doctrine, the state only was going to own the beds and banks of the tidally influenced rivers in Kentucky, which means none of the rivers in Kentucky. So as a result, all the rivers in Kentucky are by state law deemed non-navigable, and their beds and banks are in private ownership. Kentucky fairly quickly figured out this was a bad policy to leave all these rivers in private control, so it had to do an about face and said, yeah, okay, beds and banks privately owned, but the public can use all the navigable, in fact, waters, creating one of the many places in the country where you have a split, privately owned beds and banks, nevertheless subject to a public easement of use. Okay? But Kentucky was one of the first places to do that. All right. Like I said, the navigability in fact doctrine was itself an evolution of the public trust doctrine from England, and states have continued to work on evolving the definition of waters covered by the public trust doctrine. So, again, that basic rule early on was the public trust doctrine was going to apply to the waterways for which the state acquired ownership of the beds and banks. Publicly owned waters subject to those public servitudes, public uses. States started moving away from that. First way they started moving away from that is coming up with their own state law definitions of what counted as navigable. Usually much more generous than the federal test. I'll get to some of those in a minute. State expansion number 2, and this is especially true in the West, and it is true in Montana as well, is states would declare that regardless of who owned the beds and the banks, the state or the public owned the water itself. And as a result of that, many of the states in the West have taken that public ownership of the water itself and said, therefore, the public trust doctrine applies to all the water in the state. Again, we get the dichotomy of the public trust doctrine may apply to waters where the beds and banks are privately owned. The submerged lands are privately owned. Nevertheless, the water itself is impressed with the public trust. So, examples. This is really utilitarian, and I love the historical examples to prove that point, all right? So, Oregon, 1869, case of Felger versus Robinson. Oregon Supreme Court expressly adopts a log flotation test for navigability. Any water in Oregon that can float a log, subject to the public trust doctrine. Why did they do it? Here's the court itself. We think it the rule that best accords with common sense and public convenience, for these rapid streams penetrating deep into the mountains are the only means by which timber can be brought from these rugged sections without great labor and expense, and by their use, large tracts of timber otherwise too remote or difficult to access can be rendered of great value as the country shall grow and timber become scarce. Completely utilitarian decision. We need them to be public because we want the timber getting to market. They're public. Okay. Tennessee has got a bizarre little system. Unlike Kentucky, it rejected tidal navigability and went with navigable in fact, recognizing that it was in fact landlocked and not influenced by the tide. So it avoided that problem. But it came up with 3 categories. It's got the essentially navigable waters, which are traditional navigable for commerce waters. Those are publicly owned, subject to a public trust. Then it has a second category, that waters that are navigable for purposes other than commerce, largely recreation, protecting recreational use. So waters that are navigable for other purposes besides commerce, bed and banks, privately owned, but the public has a right to use those waters for any use it wants. Third category, things that aren't navigable in any sense, privately owned, privately controlled. That's Tennessee, trying to protect a rafting industry, very clearly. All right. Arkansas, case of State versus McElroy, 1980. First time the Arkansas Supreme Court had considered the question of navigable waters since the 19th century, and its recreation industry had developed considerably in the interim, river rafting and kayaking in particular. And the state Supreme Court said, look, we haven't revisited this question since the steamboat era. And we're not going to be bound by something that made sense in the steamboat era. What we need now is a definition that works for our needs now, our public needs now. We'd always indicated that this doctrine could evolve. They made that part up just a tad, but we always said it could evolve. We're going to evolve it, and so any river in Arkansas that can be used for recreation is subject to the Arkansas Public Trust Doctrine. Very conscious evolution. provoked a embittered, shall we say, dissent. All right. My personal favorite is Alaska. Alaska's got some unique needs, shall we say, for its navigable waters. And so navigable water in Alaska is defined by statute. And for public use purposes, for purposes of the public trust doctrine, where the public can use the waters fairly unrestrictedly, a navigable water is going to be any water of the state that is navigable, in fact, for any useful public purpose, including but not limited to water suitable for commercial navigation, floating of logs, my favorite, landing and takeoff of aircraft, public boating, trapping, hunting, waterfowl hunting, hunting aquatic animals, fishing, and any other public recreational purpose. So we need it for seaplanes, anything where a seaplane can take off and land. It's the only state that's got seaplanes explicitly in its definition, but I like that part of it. All right. So you can expand the waters that are covered by your public trust doctrine. You can expand the uses that you're willing to protect. And states have done that too. Again, 3 standard public uses mentioned in Illinois Central, pretty much accepted by all 50 states. Navigation, fishing, and commerce. If you're going to expand your public trust doctrine, the first thing you're going to add as a use is recreational use, rafting, kayaking, other forms of recreational boating, recreational fishing in some cases. And the states have kept going. So, at least a few states protect ecological integrity and ecosystems through the public trust doctrine. Some protect water quality. They subject their Clean Water Act implementation to their public trust doctrines. Aesthetic values and public access have all been incorporated into various states' public trust doctrines. So, Oklahoma, very consciously, 1969. So don't care if it's navigable, in fact, for commerce. If you can fish it, you can use it. So recreational fishing, very explicitly protected in Oklahoma. South Carolina, very expansive. South Carolina, maybe surprisingly, has one of the most expansive public trust doctrines in the United States. The underlying premise of the public trust doctrine is some things are considered too important to society to be owned by any one person. Under this doctrine, everyone has the inalienable right, it should be inalienable right, to breathe clean air, drink safe water, fish and sail, recreate on the high seas, territorial seas, and navigable waters, as well as land on the seashores and riverbanks. So you've got environmental quality, you've got anti-pollution protection, you've got access, as well as the more standard uses protected. Ecological public trusts are one of the newer developments, and not always where you would expect them. Texas, for example, very clearly tied its public trust doctrine way back in 1942 to natural resources management. And so that part of the public trust doctrine is, in fact, protecting the natural ecology of Texas. California is the most famous for doing this, 1971, Marks versus Whitney. So that, hey, preservation of the lands in their natural state is a public trust use. So that ecological preservation itself is a public trust use. Hawaii, even more expansive. The maintenance of waters in their natural state constitutes a distinct use under the Water Resources Trust. And now going into the atmosphere and climate change. So a series of cases recently, most not completely resolved, seeking to expand the public trust doctrine expressly to the atmosphere and expressly to greenhouse gas emissions. So, like I said, a lot of these still being decided. Connecticut has had a statute on the books for years that recognizes the public trust in the air, and there's a lot of case law out of Connecticut backing that up, being warped into climate change mitigation policies. Arizona, in March of this year, wouldn't say no. I can't say that it said yes, but it wouldn't say that the Arizona Public Trust Doctrine did not cover the atmosphere. It left the question open. District court, trial court in Texas, 2012, said that the Texas Public Trust Doctrine, we already said, it covers natural resources. That includes the atmosphere. That includes regulation of greenhouse gases. What the Texas Supreme Court will do with that, we're still waiting to see, but that's what the Texas District Court said. And then finally, New Mexico, another district court, again, refusing to rule that the atmosphere was not covered by the public trust doctrine. Not positively ruling that it was, but refusing to rule that it wasn't. So this is the newest one that's emerging. And this is kind of the vanguard of that. So again, expansion of use is covered. And I also mentioned a lot of states have said explicitly that their public trust doctrines are in fact evolutionary. They will be flexible enough to meet changing needs. So again, not surprisingly, California, often cited for this, 1971. The public trust doctrine is flexible enough to encompass changing public needs. In administering the trust, the state is not burdened with outmoded classification favoring one mode of utilization over another. We reserve the right to change what it covers as public needs change. Of course, most famously in 1983, in the Mono Lake case, National Audubon Society versus Superior Court, said, hey, the objective of the public trust has evolved in tandem with changing public perception of the values and uses of waterways, and by the end of that case, the public trust doctrine could be used to modify existing water rights of all sorts in California, which there are at least 3 types of water rights in California. New Jersey, one of the surprising ones. New Jersey said, hey, public trust doctrine's common law principle, not fixed or static. It evolves over time to meet challenging conditions and the needs of the public it was created to benefit. As a result, New Jersey has used its public trust doctrine to assure private access to private beaches, including the dry sand portion. So both public and private beaches are now subject to public access under New Jersey's public trust doctrine. And the Superior Court of New Jersey said in 1987, this also applies to water supplies. So water quality, Safe Drinking Water Act type actions in New Jersey, at least according to the Superior Court, also subject to the public trust doctrine. Hawaii, whatever California does, Hawaii does like to another power, just as a general rule. So in 1982, said, yeah, we've got a very active public trust doctrine. We're dealing with increasing scarcity of water in Hawaii, and unlike the rest of the United States, pretty much except Alaska, Hawaii's got no real place to look for additional fresh water except the ocean. So water scarcity in Hawaii is a big deal. And so recognizing the scarcity of the resource, we are going to say that all water rights in Hawaii, as in California, are subject to the public trust doctrine and can be adjusted accordingly to deal with these shortages. All right. So addressing that public-private balance, again, I've already mentioned National Audubon Society. We can adjust the private rights to meet the public needs under the public trust doctrine. Same in Hawaii. Hawaii, like I said, it's constitutional in Hawaii. It's got 2 versions of its water's public trust doctrine. One came out of the native Hawaiian tradition and was incorporated into modern Hawaiian law. Limits water rights and water use permit. Applies to all water resources without exception or distinction, includes groundwater. Hawaii is one of 2 states that explicitly applies its public trust doctrine to groundwater. And protects recreation, ecological integrity, water quality, species, and applies to all relevant permitting regimes within the state. So the state permitting agency under the Clean Water Act in Hawaii has been sued multiple times successfully for failure to properly implement the Clean Water Act under the public trust doctrine. And also, like New Jersey, provides public access to all beaches, which is something to know when you visit Hawaii. You can, in fact, access the beach no matter how hard it actually may be. All right. In other places has emerged, public trust doctrine is a constitutional takings defense. If we do modify how you use your private property, can the public trust doctrine stand up as a defense to that? Inherent limitation on your private rights. A lot of courts have said yes. So North Carolina in 2005 said, well, when we allow beach access, that's under the public trust doctrine, no takings claim, constitutional takings claim. Wisconsin 2001 denied a dredging permit, had some impact on riparian rights, did it in the name of the public trust doctrine, therefore no constitutional takings claim. Florida in 1997 denied offshore oil and gas leases, which Florida has a history of doing. Again, did it in the name of protecting those coastal resources under Florida's fairly expansive public trust doctrine, no takings. Washington, 1987, when Washington enacted its Shoreline Management Act, it was faced with a plethora of constitutional takings claims. Said, no, this is in furtherance of our public trust doctrine, no takings. And even Montana, faced with the use of streams for recreation, said, nope, no constitutional takings, part of our public trust doctrine. So, important defense, I think more states are going to be reaching for in the future. All right, climate change adaptation. Public trust doctrines always balance those public and private interests in water. That's what it was there for from the beginning. As I've shown, often blatantly utilitarian when state courts are deciding what to do with their public trust doctrines. 16 states at least have already been willing to expand their public trust doctrines in response to perceived shortages or new public demands or changed circumstances to create those ecological public trusts. So 16 out of 50 states already have extended it to the ecology of the system. And at least 5 states have openly declared that their public trust doctrines evolve. They will continue to evolve in the future, and therefore we reserve the right to adjust both public and private rights as needs demand. So what does that mean for climate change? I think courts can use public trust doctrines as an occasion to acknowledge climate change impacts as a real threat to water resources. Courts can use the public trust doctrines to engage in cumulative assessments of what has happened to water resources in the state. Can lend support to resource agencies' experiments with adaptive management, trying to react to those changes. And most radically, courts could engage in some form of judicial adaptive management, which the California Supreme Court came close to, but punted ultimately in the Monolith case. All right, so lots of potential uses. Like I said, I expect to see more of it. So where's Montana's public trust doctrine? You guys all probably know this better than I do, so I'm going to run through this quickly. Montana's Constitution is one of the best preambles I've ever read in terms of how important the natural resources of the state are to the state. And what interests me about Montana is it's got this clean and healthy environment provision in its Constitution. But the extent to which your public trust doctrine has been expanded to recreational fishing, that's kind of unusual in terms of what public trust doctrines do. So the opportunity to harvest wild fish and wild game is a heritage that will forever be preserved. It's in the Montana Constitution. Some code provisions for recreational access, what a navigable water is, and a declaration that they'll be used for the purposes of angling. Case law, got a slightly broader test than the federal test, but all the waters can be used for recreation, and that includes minimal use of the privately owned beds and banks as well. So a couple of recent cases that caught my interest, Trout Unlimited versus Beaverhead Water Company, specifically for those cold water fish, or that's what Trout Unlimited was after. And Montana Supreme Court declared under the Montana Constitution, the public trust doctrine, the public owns an in-stream, non-diversionary right to the recreational use of the state's navigable surface waters. These are usufructuary, not ownership rights, and as a result, Montana Trout Unlimited had standing to object to water rights in favor of the fish. And the most recent one that's been published from the Montana Supreme Court, the Abo Investments case, it's a quiet title case, the Three Islands of the Missouri River, but picking up on PPL Montana said, hey, you want it to be a matter of state law? It's a matter of state law. We're willing to go with that one. All right, so what I think will be interesting in the future, and this is it, climate change is about change. Can't preserve all the old rules. Water's already becoming a stress point, so state courts, state legislatures are going to be looking for legal doctrines that help them cope. State public trust doctrines can be legal tools for facilitating climate change adaptation. And what I'm going to be particularly looking forward to out of Montana are two questions, resolutions of two questions. Can public trust doctrine rights in Montana modify other rights to water? Kind of expecting the answer to that will end up being no, but has yet to be decided. And I think more interestingly out of Montana, at least for my research purposes, is the question of how strongly Montana's public trust doctrine will protect those hot trout and the other cold water fish in the state as things get worse. That's it. Thank you very much.
Thank you so much, Robin. We've got time for a couple of questions, and then we'll adjourn for a reception out in the atrium. And we have a student with a microphone. If you want to raise your hand, they can bring the microphone to you if you have a question. Question over here.
Thank you. I'm not an attorney. I'm a state legislator.
Uh-oh.
But I am very interested in your speculation on the last question, was whether or not the public trust doctrine in Montana would be allowed to modify existing rights, and particularly water rights. I've been invited, and other colleagues of mine have been invited to sponsor legislation which would, in effect, assure in-stream flow for fisheries during low water years by and it would be quite intrusive in terms of the existing water rights that exist on those waterways. And the legislative legal staff has indicated that there would be a potential takings issue there, and their general supposition is that indeed what you're saying is true, that we wouldn't be allowed to modify those rights in that way. But I'd like you to expand a little bit more on your prediction on that score.
Okay, well, if you actually had legislation in place, I mean, the general rule is that state legislation is presumed valid. I mean, that's just a general rule. And if it was enacted, particularly saying this is an implementation of the public trust doctrine in Montana, as it has always been understood in Montana, which is the legal fiction that gets you around the takings clause. And if you, I mean, you do have the case law going back to the 1980s that says this is a use, we're protecting recreational fishing, we have to protect the resource to go with that, which is the logic that a lot of states have used, that the public, if you let the fish die, the public trust use dies with it, is a statement of fact. I mean, you have to protect the resource. Washington has used this logic in a lot of its public trust regulation of fisheries in Washington, is we can't let you willy-nilly do whatever you want because that destroys the resource. Same with water rights, potentially. We can't let you willy-nilly take all the water out of the stream because we're destroying this other public trust resource that has it's enshrined in the Montana Constitution as being an important heritage of the state. So I think there would be some legally defensible ways to do it. I don't deny that there is a little bit of legal hand-waving and abracadabradness about some of this, but if you really need the law to evolve, sometimes you need that abracadabradness. And if you want to see two ways to do it, I would point you to Arkansas and State versus McElroy, where they found a long legal tradition of public trust protections being able to evolve to serve society. And when Florida adopted its new water resources code in 1972, the Florida Supreme Court faced down a takings challenge because it dramatically altered the way riparian rights were. I basically replaced riparian rights in Florida with something that's a blend of prior appropriation and riparianism. They faced down a takings challenge by basically saying, your rights were inchoate to begin with. So we're doing this for the public benefit. It works. No takings. So like I said, I think you could defend it. I would also watch, however, what's going on in Texas, because the Texas lower courts have just found a takings of water rights as a result of groundwater regulation in the Edwards Aquifer, and it will be interesting to see what the Texas Court of Appeals and the Supreme Court does with that on appeal. So I'm not guaranteeing it'll work, but there are ways we could set it up to give it a decent shot.
Maybe one more question.
You kind of briefly went up over climate change, and I'm kind of more curious on how you think climate change maybe breaches public trust, or what the effect is on that, and how would somebody, legislate or take some sort of legal action against climate change?
You can't take the action against climate change, all right? I mean, there are ways to try, but they haven't been too successful so far. That's not my point. My point is that there are a lot of legal avenues for adapting to the impacts of climate change that we haven't really played around with yet. If the atmospheric scientists are right, it takes about a century for any of the carbon dioxide to cycle out of the atmosphere, so we're going to be dealing with this for a while. And so rather than suing to stop climate change, which is another aspect of climate change law I don't find near as interesting as this aspect, what I'm advocating is you can reach for legal doctrines like the public trust doctrine, like a public necessity doctrine, which hasn't been used in a long time, to find ways to alter traditional principles of law or even more recent principles of law where you need to protect some of the public rights. So, for example, if climate change impacts on water resources in Montana are making it impossible for various population of trout to continue to exist in the state and people be able to take water out of the stream simultaneously, those two uses end up being in conflict. There are doctrines that can help you resolve those cases in favor of the trout instead of in favor of the water users. Whether you want to use them or not is a matter of politics, it's a matter of state priorities, but they do exist. And like I said, I expect that certain states at least will be reaching for them more and more. Does that answer your question?
Yeah, it's sort of more of a reactionary approach, though. It's not necessarily a proactive. You're not solving the problem, you're just making it so efficient.
I'm trying to save them as long as possible, yes. Yeah, and those are two different legal problems. If you want to solve climate change, you need a carbon dioxide emissions regulatory scheme. That one's got a very clear solution and no political will to implement it. Okay? Easy, I mean, it really is. Conceptually, it's an easy solution. Implementing it is politically impossible, or has been at least in the past. Adaptation, on the other hand, is legally complex. It's going to be necessary, by all predictions, lots of different ways you can try and approach it, and that's what I'm trying to point out, is there are legal doctrines already out there that could be used to help that along.
Thank you so much.